Christopher Gregor and Corey Michillo's mother were in a relationship during which Corey was born. Details about their relationship, including any separation or custody arrangements, have not been widely publicized, but it is clear that Gregor was Corey's biological father and had periods of custody or visitation. Lead up to the incident. Reports indicate that there were prior allegations and signs of abuse by Christopher Gregor towards Corey. Family members and others had raised concerns about Gregor's treatment of his son. Investigations later revealed surveillance footage from the family's apartment complex showing instances of Gregor's aggressive behavior towards Corey. This footage was critical in highlighting the pattern of abuse.
I'll move to the next video, which would be S18C for purposes of the record.
Very good.
In the CCTV video, Corey is seen continuously falling off the treadmill, while Gregor keeps lifting him up and putting him back on it. Gregor is seen at one point appearing to bite his son on the back of the head before forcing him to run again. In opening statements, Gallucci admitted the jury were going to be horrified when they saw the footage, but argued it did not contribute to Corey's death. "You're going to be mortified," he warned, but Corey's death had absolutely nothing to do with that treadmill. In emotional testimony this week, Michillo said she immediately noticed bruises and scratches on her son after the trip to the gym, as she claims to have done after numerous other visits. He had a bruise on his forehead. "It was very odd-shaped. It looked like an impression," said the mother through tears. She added that he also had other cuts on his body, including one on his chest that looked like a scrape. A pediatrician examined the injuries, and although they said the mother should not be concerned, she testified that Corey told the doctor that he was forced to run on the treadmill because he was too fat. Michillo also reported the injuries to a caseworker with the New Jersey Division of Child Protection and Permanency, with Corey's death coming just one day after courts rejected an emergency filing seeking custody of her son. She previously warned authorities as far back as July 2020 that her son would return from his father's home with black eyes, bruises, scrapes, and even bite marks.
Your Honor, permission to publish video. Now, Brianna, who is the child located in that video?
That's Corey.
And how old was Corey in that video?
He was 6.
And who is the adult male located in that video?
The defendant.
And again, you're familiar with that area?
Yes.
Now, when was the first time that you ever saw that video?
A few weeks ago.
And have you ever had possession of that video?
No.
Your Honor, there's no further questions for the witness at this time.
On April 2, 2021, just over a week after the treadmill event, Christopher Gregor took Corey Michillo to the hospital. Corey was in critical condition upon arrival. Lindsay Carnevale, one of the nurses at the Southern Ocean County Medical Center who tried to save Corey, testified in court. She says that Gregor left the room at around 4:51 p.m. on the day Corey died, never to return while the boy died at 5:02 p.m. Prosecutor Christine Lento asked Carnevale, "Who stayed with Corey?" She responded, "We did. We were the only ones with him for those last 9 minutes of Michillo's life." Carnevale said that Gregor showed absolutely no emotion upon bringing Corey to the hospital at 3:53 p.m. She claimed that Gregor had told her Corey's mother, Brianna Michillo, was a drug addict and didn't want her to be informed. According to court testimony from William Doyle, the nurse on duty at the time, Corey was taking dire, almost end-of-life breaths as he was admitted to hospital. Doyle said Corey was not showing any signs that he was verbal and slumped his head back when he was examined by doctors, reports the Asbury Park Press. He described panic inside the hospital as medics tried to save the boy's life, branding it an all-hands-on-deck situation. A forensic pathologist later ruled that Corey's death was a homicide caused by blunt force trauma. However, Gregor's attorneys argue his son actually died from pneumonia. When a CT scan was administered to Corey, he also suffered a seizure. Frantic attempts to save his life were tragically unsuccessful, and he died hours later at around 5 p.m. It comes amid revelations the New Jersey father only met Corey a year before he allegedly abused him to death. Amid outrage over the treadmill footage, archived text messages from the boy's mother alleged to show him coldly brushing off his treatment of the child. After she texted him about how he hurt Corey's feelings, Gregor responded, "Maybe he needs to be a little tougher, because that's soft tissue." Sergeant Raymond Coles with the county prosecutor's office testified that Gregor was seen walking out to his car and driving away by 5:20 p.m., according to hospital surveillance footage. Coles said that Brianna Michillo called Gregor 3 separate times within minutes of their son being pronounced dead. Gregor never responded. A sergeant with a local police department then called the father himself twice, minutes later. Again, Gregor ignored the calls, according to Coles. Coles then testified that searches of Gregor's phone revealed that at 6:10 p.m., just an hour after his son died, Gregor searched, "Can your phone be traced in airplane mode?" and "Can my car be tracked?" The next day, Gregor searched topics such as what would cause a rise in blood sugar in white blood cells, and if internal bleeding could raise your blood sugar level, as well as wondering how gastrointestinal bleeding is caused and if such a bleed can be slow. Further damning searches were found on Gregor's phone on April 4th, 2 days after Corey died. Coles said that Gregor asked a search engine, "There was a murder determination from an autopsy. How long to file charges?" The extraction from Gregor's cell phone also revealed that he deleted approximately 3,466 text messages with Brianna Michillo. Gregor was arrested 3 months later on charges of child neglect, with his arrest warrant noting the gym surveillance video as a reason for the arrest. Specifically by having Corey run on a treadmill and increasing the speed, causing Corey to fall, placing him back on the moving treadmill while appearing to bite his head, causing the said child to fall several more times, the warrant read. In September, a forensic pathologist ruled that Corey's cause of death was homicide due to chronic child abuse, including blunt force injuries to his abdomen and chest, and a laceration to his heart. It was also found that the boy suffered cardiac and liver contusions with inflammation and sepsis. Although Gregor is reportedly claiming his son died due to pneumonia, it is unclear if any medical staff found this to be the case in hospital, where Corey also suffered a seizure during a CT scan. On March 9, 2022, almost a year after his son's death, Gregor's charges were increased to murder.
His son's mother then decided that to take it upon herself during the 3-hour visit yesterday to take my son to the doctor, to the hospital, and she just went radio silent essentially from 7:30 until 1 o'clock in the morning. And I had no idea what was going on. She would not leave my son's side, and I was not able to be there for my son. And then furthermore, my son came back this morning, and he was stating to me that his mom said that he had to tell the doctor that I had hit him and things of that nature and coaching him.
Doctor, were you contacted by the Ocean County Prosecutor's Office in regard to the decedent, Corey Michillo?
Yes.
And can you tell the jurors why you were contacted?
I received initial contact from the Ocean County Prosecutor's Office in September of 2021. They asked me to review material related to the death of Corey Michillo with an eye toward rendering an opinion as to cause and manner of death.
Now, doctor, did you prepare reports in regard to your findings and opinions regarding this matter?
I did.
Your Honor, if I may approach counsel?
Yes.
Thank you. If I may approach Doctor, I'm now showing you what has been marked S50, S51, and S52. Do you recognize those?
I do.
And can you tell the jurors what those are?
S51,
Are those your reports in this matter?
yes,
And would those reports aid in your testimony today?
yes.
Now, did you perform the autopsy of Corey?
No.
Can you tell the jurors who performed the autopsy?
Dr. Ragasa, Dante, I believe is his first name, Dante Ragasa, of the Ocean County Medical Examiner's Office, performed the autopsy examination on Corey.
And when was the autopsy performed?
Autopsy was performed in April of 2021. Let me see what the specific date was. On the 3rd of April, 2021.
And did you review the autopsy report authored by Dr. Ragasa?
I did.
And what other materials did you review to formulate the basis for your opinions?
In addition to the autopsy report, I saw the images that were generated in association with the autopsy. And I examined the histological slides, and we'll talk about those momentarily. The slides that you look at under the microscope. So I looked at that. And then I had medical records from 3 different hospital facilities. I believe it's County Medical Center and Jersey Shore Medical Center and South Ocean. I saw medical records from IV Pediatrics, which were Corey's pediatric care provider. Certainly I saw police documentation, law enforcement documentation. I saw some telephone records. I had access to a video of Corey on a treadmill. And subsequent to issuing my first report, I received additional materials. I did receive an expert report from an infectious disease specialist, Dr. Feingold, and a report from a defense pathologist expert, Dr. Bott.
Did you also review video from April 2nd of 2021 from the decedent's mother's phone occurring around 9 a.m.?
Indeed, I did, yes.
And you also reviewed autopsy photos?
Yes.
Do you have an opinion after you reviewed all of this material in regard to the decedent's cause of death?
Yes.
And can you tell the jurors what that opinion is?
I'm simply going to quote from my report, and because it's a mouthful, and we'll break it down. But Corey died of blunt impact injuries of the chest and abdomen, with laceration of the heart, left pulmonary contusion, and laceration and contusion of the liver.
And can you explain to the jurors when you say cause of death, what does that mean?
Cause of death is, it sounds simple enough, but it's something that's very specific. Cause of death is the disease or injury or combination of those things that initiates what's ultimately a lethal train of events, and without which death would not have occurred. So there are many, many, many causes of death.
And what about blunt force trauma? Can you explain to the jurors what that means?
In forensic pathology, there are various kinds of external forces that can act on the body. There could be penetrating trauma, such as that from gunshot wounds or stab wounds, or there can be blunt impact injury. And in that situation, you have force applied to the body over a much broader area than a single bullet or blade would cause. That blunt impact could be a small area or a large area, but it produces a different kind of injury than penetrating trauma does. And the kinds of injuries associated with blunt impact include contusions or bruising of the skin or internal organs, lacerations, tearing of tissue because of the result of the blunt force applied to it, or fracture of bone.
And what affects blunt force trauma and the impact on the body?
Well, the impact can be anything from minor to life-threatening. If you get up in the middle of the night in a strange hotel room and hit your shin against a nightstand, that may raise a contusion. But all that is bleeding under the surface of the skin, and that will resolve over time, and that will be fine. If you were to fall against that nightstand, you might sustain a laceration of your scalp. That may require stitches, but likewise you would recover from that. If you sustain any of these kinds of blunt impact injuries with sufficient severity, it could conceivably bring about your death if they were severe enough.
After reviewing the materials in this case, did you formulate an opinion as to the decedent's manner of death?
I did.
And can you tell the jurors what your opinion is?
Corey's manner of death is homicide. While there are many, many, many causes of death, typically in forensic pathology, there are only 5 manners of death. And manner of death is simply a one-word description to explain how a death came about. And those 5 are natural, accident, suicide, homicide, or in rare instances, undetermined. In Corey's case, in that these injuries could not have been inflicted by himself with any kind of intent, it's certainly not suicide. These injuries, given their pattern and distribution, are consistent with having been inflicted by another person. Therefore, any death that is related to the actions of another person is, from a medical examiner's standpoint, from an epidemiological or public health standpoint, homicide. Now, it doesn't have any legal significance, but that's the way that a medical examiner certifies it. So Corey's death was at the hands of another person, therefore it is a homicide.
Does a case histology impact the determination of manner of death?
Well, it can in certain instances. If you have a gunshot wound to the head with a perforation of the skull and brain, histology or examining tissue under the microscope doesn't add a whole lot. But in a case like this, certainly the examination of the tissues under the microscope was helpful in reaching my conclusions.
Did you make any findings regarding Corey's medical records from Southern Ocean Medical Center on April 2nd of 2021?
And I'm going to ask you to clarify that a little bit because I'm not entirely certain what the question is.
Did you review the medical records from Southern Ocean Medical Center on April 2nd of 2021?
Yes, I reviewed those records from April 2nd.
And can you tell the jurors if that helped to formulate your opinion as to cause and manner of death?
It did, yes.
And can you explain why?
Well, Corey presented to Southern Ocean at around 3 o'clock. At that point, he was already in serious medical condition. He was ashen, gray, in a shock-like state, and was fairly medically unstable. There was an attempt to make an assessment as to what might have been going on with him by doing a CT scan, and he got worse in the CT scanner to the point where he underwent a cardiac arrest.
And doctor, did you review any blood work from that hospital?
Yes.
And did that impact your conclusions?
Yes.
And what about any post-mortem CT scans?
He had a post-mortem CT scan. I don't find those of particular value, certainly compared to an autopsy, as to determining cause and manner of death. But I did see that there was a postmortem CT scan, and I looked at its result.
Did you review the medical records from Jersey Shore Medical Center the evening of April 1st of 2021?
I did.
And can you tell the jurors about that?
Well, that particular visit was at the end of a sequence of events wherein Corey initially was seen by his pediatrician. There were some concerns about these bruises that Corey had as to whether or not this represented some mistreatment or child abuse. So Corey was referred to the emergency room, and I believe Corey and his mom went to one, but then they went to Jersey Shore after that. At that examination, he had a physical done, and they documented the various bruises that he had on different parts of his body, none of which were life-threatening. His clinical status at the time was perfectly stable. He was normal, he was conversational, he spoke with the doctor, he gave history, he made some disclosures. They also did some blood work and an x-ray of his chest, and all of that was completely normal.
Did you review the findings from Dr. Ragazza's autopsy performed on April 3rd of 2021?
I did.
And can you tell the jurors what Dr. Ragazza's findings were?
So Dr. Ragazza received, the body was taken to the medical examiner's office, I believe, the night before, but Dr. Ragazza performed his examination on the 3rd and documented all of the bruises or contusions that were on various aspects of Corey's body. Those were the primary external findings that he had. But an autopsy is a very detailed surgical examination of not only the external aspect of the body, but the internal aspect as well. There's a large Y-shaped incision made from the shoulders to the middle of the chest and down the center of the body, allowing the pathologist to take a systematic examination of each of the organ systems. It was during that internal examination that Dr. Ragazza saw and documented several abnormalities. There was a large contusion of one of Corey's lungs, I believe it was the left lung. Examination of Corey's heart externally didn't show anything, but on the internal examination of the heart, after the heart was opened to reveal the chambers of the heart, a laceration or tear in the tissue was revealed near the apex or the tip of the heart, on the inside wall of the heart. Below the diaphragm is that flat muscle that divides your chest organs from your abdominal organs. Below the diaphragm, on the right side where the liver lives, there were two injuries that he documented. There was a laceration or tear in the liver tissue on the right edge, the right lateral aspect of the liver, and there was also a contusion or bleeding underneath the capsule of the liver on the front edge of the liver. There was a small amount of free blood in the floor of the pelvis, undoubtedly associated with the liver laceration.
The verdict in Christopher Gregor's case was reached in late 2022. The jury found him guilty of all charges, including endangering the welfare of a child. The specific charges and sentences included guilty of aggravated assault. Gregor was found guilty of the aggravated assault of his son, which contributed to Corey's death.
It is clear that the offenses in this matter involve cruelty to this particularly young child of tender years who was incapable of resistance. That mandates the court place heavy weight on aggravating factor 9, so it provides strong deterrent to this defendant, as well as strong deterrence to others who would commit crimes against children, particularly children of tender years such as Corey. Defendant's a big, strong individual. His family has repeatedly talked about his athletic prowess. He was not only a high school but a college football player. The pre-sentence report details his height and weight. 6'1", 220. Corey's a little boy. Was a little boy. And he deserved protection from his father, not abuse from his father. Mr. Gallucci has been a zealous advocate, and he has both in writing and orally argued for a series of mitigating factors. Mitigating factor 2 can be present when a defendant did not contemplate that his conduct would cause or threaten serious harm. While I respect defense counsel's position, everything you see on that treadmill contemplates at least the threat of serious harm. In fact, it's almost difficult to accept the medical testimony that the treadmill did not cause serious injuries. Dr. Andrew, I believe even Dr. Bodden, testified there were some abrasions, some bruising, but Corey did not sustain serious harm from that. But any reasonable, objective person watching that video would certainly say it threatened serious harm, particularly for such a small child. It would threaten serious harm for an adult to be on a treadmill and not be able to keep up, and then to try and jump back on. And I don't think the 6-year-old was jumping back on his own initiative. He was doing it because he was scared, he was being told to, and he was following his father's directives. So there's no basis to find that mitigating factor 2 exists. Mitigating factor 7 has been argued that a defendant has no prior history of delinquency or criminal activity or has led a law-abiding life for a substantial period of time. So I'm required to give some weight to that factor because the defendant has no felony level convictions in this or any other state, no indictable crimes in this or any other state. He has one ordinance violation and the one drug paraphernalia that I've just talked about. So while not perfect, it's certainly not a serious record. Despite everything that everyone has said about arrests in other states, it's a little difficult to accept that if someone's arrested multiple times in all these jurisdictions, that no prosecuting attorney chose to file charges, or if they did, they were very quickly dismissed. So the that this defendant has a serious record is just unfounded. I'm confident that the prosecutor's office would have submitted to me records of convictions that they existed anywhere. I mean, there are times I get records of convictions from Puerto Rico, and it takes the prosecutor's office a great deal of time and effort to get those. So here we have a series of police reports, which I can't consider. They're mostly one-sided hearsay anyway, but I'm not permitted under the case law to consider those. So I have to recognize some weight to be given to the lack of a record. So I give it moderate weight. But as I said, the disorderly person conviction is particularly telling because of the date involved. And it's when the defendant should know better, when he should be a law-abiding citizen, because he's trying to battle for custody of his child. So why engage in that drug use? And that's particularly true because the defense has, and I'm sure they felt obligated to, continue to raise Corey's mother's drug use, particularly during cross-examination and trial. So I find mitigating factor 7, but give it moderate rather than heavy weight. Defense counsel has also argued for mitigating factors 8 and 9, and they're somewhat similar. 8 would be appropriate when the defendant's conduct was a result of circumstances unlikely to recur, or the defendant's character and attitude indicate that he's unlikely to commit another offense. Those two mitigating factors, 8 and 9, are counterparts to aggravating factor 3, the risk to commit another offense. I've already found aggravating factor 3 exists, and it should be given moderate weight. Therefore, it's generally considered inappropriate to find mitigating factor 8 or 9. But regardless, those factors are not present, period, for the reasons I've indicated. I agree with the position of the state and the victims that defendant was motivated by anger, that he took advantage of someone who couldn't resist, someone of tender years, incapable of resistance. The treadmill video demonstrates Corey's fear. Someone who does that, who has that disposition, is likely to reoffend. Therefore, 8 and 9 are not present. Although not argued, mitigating factor 11 is likewise not present based upon the defendant's injuries as reported in the pre-sentence report, for the reasons I've indicated, that the sports injuries and the left ankle injury can certainly be addressed by medical staff in any correctional facility, and if not, that correctional facility would transport the defendant to a hospital to be treated. So therefore, those do not overcome or even lessen the presumption of imprisonment. Based upon all the foregoing, then, I'm clearly convinced that the aggravating factors substantially outweigh the mitigating factors. So now I need to impose sentence, and then I'll address the state's request for whether the sentence should be consecutive or concurrent. I've appreciated that everyone has asked me to impose the maximum sentence. And I appreciate the emotion that's involved, the comments, and you've heard many of the things I just said about the treadmill video and the callous behavior. Imposing the maximum sentence is just legally unsustainable by me. There's no appellate court that would say someone with only a very, very minor criminal record should get the maximum. It just doesn't happen, despite the public perception that it should happen. So on count 2, aggravated manslaughter, I sentenced the defendant to the custody of the Commissioner Department of Corrections for a term of 20 years, subject to the No Early Release Act, New Jersey Statute 2C:43-7.2, such that he has to serve 85% of that sentence before being eligible for parole. On count 1, endangering the welfare of a child, a second-degree crime, I sentenced the defendant to the custody of the Commissioner Department of Corrections for a term of 5 years. The defendant has 885 days of jail credit. So I have to address the requests for consecutive sentences. Again, there's a great deal of guidelines the court has to follow and a great deal of Supreme Court case law on this. The factors involve, first, the principle that there should be no free crimes. Secondly, whether or not the crimes and their objectives were predominantly independent of each other. Whether the crimes involved separate acts of violence or threats of violence. Whether the crimes were committed at different times or separate places, rather than being committed so closely in time and place as to indicate a single period of aberrant behavior. Whether the crimes involved multiple victims. And whether or not the sentences to be imposed are numerous, meaning multiple counts. Here we have 2 counts. With the proviso, again, that can be no double counting of aggravating factors. When there are multiple crimes involving multiple victims, the law is that the total impact of singular offenses against different victims will generally exceed the total impact on a single victim. We don't have that here. We have a single victim. But first, not to impose a consecutive sentence for the endangering would be to make that endangering offense a free crime. And one need only view the circumstances of the offense and the video to know it shouldn't be a free crime. The crimes are somewhat interrelated. They're not completely independent of each other, but they are predominantly independent of each other. Corey was subjected to an awful time on the treadmill that I've described. It was brutal to watch that treadmill video because you rarely see a child essentially inflict harm on himself in the beginning until his father starts to put him back on it. So it doesn't take a vivid imagination to consider the fear Corey's in at that point. The 2 incidents are approximately 12 or 13 days apart, although they both occur in Barnegat. They're at different times, and they are at separate places, although relatively close together, the gym at the complex and the defendant's apartment at the complex. But they're not so sufficiently close in time as to be a single episode of aberrant behavior. This is not someone that went and committed 4 car burglaries in a parking lot, one after another, which would be a single episode of aberrant behavior. that clearly involved separate acts of violence and or threats of violence and harm to Corey. The second act being the ultimate act, which was successful in ending his life. They don't involve multiple victims. So I conclude, for those reasons, that it would be to send a message to the public, to the defendant, and to those who abuse children, that you can get away with one offense if you get caught on the other. And that's simply inappropriate for deterrent reasons in general or for specific deterrence in this case. And therefore I conclude that count 1 and 2 should be consecutive. The law requires me to make a additional statement on the overall fairness of a consecutive sentence. This is a requirement imposed by our Supreme Court in State v. Torres, 246, New Jersey, at page 246, a 2021 case, where our court held that the trial judges to make an explicit statement of fairness that explains the overall fairness of the consecutive sentence. So first, I've imposed sentence on the second-degree crime at the bottom of the second-degree range. Second-degree range is 5 years to 10 years. I conclude that if I were to go greater than the bottom of the second-degree range, I would be subject to an abuse of discretion as that being excessive. Secondly, the endangering sentence is not part of the No Early Release Act. It does not contain a court-imposed period of parole and eligibility. It's referred to as a flat sentence. Additionally, I conclude that the consecutive sentence is fair because of the reasons I just articulated about no free crimes. Defendant is 32 years of age. Absent some unusual medical event for a young person, he will eventually be released to his own liberty. He will eventually be a free man to walk around. Corey, of course, will not. So this is not the functional equivalent of a life sentence, despite the imposition of a consecutive sentence. It's also fair and just, given some of the testimony by Dr. Andrew, who testified in great detail about this, got down off the witness stand, went to the large screen TV and pointed out the bruising all over Corey's body, and testified about the injuries and bruising of different ages in different levels of healing, demonstrating the doctor's concern about ongoing abuse. We had pretrial hearings about this. The state, in count 1, endangering originally alleged abuse, was occurring from December of 2020 through March of 2021, up through the date of Corey's death. I concluded that, really to protect the defendant's right to a fair trial, I concluded that many of the other incidents were attributed to normal childhood activities. Going hiking and getting a branch that comes back from a shrub into the tree, playing sports. And because there was what I found to be insufficient medical documentation or medical testimony that those incidents were attributed to abuse, I did not allow them in. But Dr. Andrew, who did not testify in that pretrial hearing but testified later, was very compelling about those levels of injury and their different states of healing. Kids get bumps and bruises. Corey had more than bumps and bruises that you would see on a 6-year-old. So for all the foregoing reasons, I conclude the imposition of a consecutive sentence is overall fair under the circumstances of this case. The state's taken an additional position that I should impose the least restrictive or flat prison sentence first, such that it precedes the more restrictive prison sentence, meaning that the defendant should serve the endangering sentence before the aggravated manslaughter sentence. There's a very difficult legal analysis associated with that. I rely upon State v. Ellis. It's an television case from 2002, 346 New Jersey Super 583. And a Supreme Court opinion in State v. Pierce, P-I-E-R-C-E, 220 New Jersey 205, an Supreme Court decision from 2014. It is legally possible. In fact, what the Ellis case says is, while it's not illegal, it's difficult to justify. And it typically runs afoul of certain sentencing guidelines, and it may interfere with the expertise of the parole board in determining when a defendant should be released on parole. And based upon both of those decisions, I conclude that I cannot impose the least restrictive sentence first without engaging in an abuse of discretion. So therefore, I direct that the No Early Release Act sentence on the aggravated manslaughter count run first, followed by the flat sentence on the endangering count, such that the aggregate sentence is 25 years and that the jail credit of 885 days comes off the aggregate sentence. Another condition of the No Early Release Act is that defendant shall serve a 5-year period of parole supervision upon release, that he shall provide a DNA sample and pay for the cost of same. There are 2 $50 victim of crime compensation assessments, 2 $75 safe neighborhood assessments, 1 $30 law enforcement training and equipment fee. The superintendent of the institution where defendant is incarcerated shall draw sufficient monies in an amount not to exceed 1/3 of the inmate's total income as may be required to pay these assessments. The Office of the Victim of Crime Compensation Board submitted a request for restitution for funeral expenses. There's been testimony during the course of the case about whether or not defendant's parents paid for funeral expenses, whether or not the Ms. Michillo's family paid for them through the VCCO office. I've considered, am I supposed to hold a hearing on that? And I conclude that the parties need closure in this matter. They don't need another hearing on whether or not those expenses actually went to the funeral, or and the VCCO letters also refers to some other expenses not associated with the funeral that may not be directly attributable to defendant's conduct. If these were out-of-pocket expenses by anyone qualifying as the victim, I'd be inclined to consider them further. The Office of the Victim of Crime Compensation Board exists for the benefit of victims. It charges, the defendants are assessed, like this defendant's been assessed, 2 penalties for that, to fund that, and I conclude at this point that it's not appropriate to order that restitution because of the questions concerning who paid for the funeral, and more importantly, I would have to do an analysis of the defendant's ability to pay now or in the future. He's been incarcerated for the last 885 days. He's been unemployed. He clearly has no ability to pay now, and he has little ability to pay for the next 25 years. So I conclude, for those reasons, that mitigating factor 6 is not present. There's no restitution to be paid, no ability to pay restitution. Therefore, I do not order restitution. If there's any bail in this matter, it's discharged. There are no dismissals. Madam Clerk, is there anything else I need to address? And Mr. Gallucci, we get an appeal rights form? All right. Anything further from counsel?
No,
All right.
Judge, thank you.
Thank you, everyone, for your excellent presentations. That concludes the matter.
Thank you.
Wait, do not exit yet. The back row's gonna...
Our hearts go out to all the family and friends of this beautiful little boy, Corey. We hope he may now rest in peace. Please let us know what you think of this case and whether you think this man got what he deserved. As always, please like, share, and subscribe to our channel. Until next time, this is Sinister Stories.